as a practicing lawyer based out of Seattle, who's handled a wide variety of protection orders, both defending and prosecuting, from Bellingham down to Olympia and many places in between, I've come to some general conclusions about protection orders that I think help somebody understand when to seek them and what they're really about. Domestic violence protection orders, anti-harassment protection orders, vulnerable adult protection orders, and sexual assault protection orders are really designed to stop scary and intimidating, harassing, assaultive behavior that may not, for whatever reason, actually doesn't qualify for criminal prosecution. And the problem is that there's a gray area of behavior that may not qualify for criminal prosecution but should stop. And that's what protection orders are all about. In order to catch that behavior and stop it, they turned them into civil protection orders, not criminal protection orders. And they did two really important things, the legislature, that is, and the lawyers that work there. They dropped the standard of proof for a civil protection order, and they changed the rules of evidence. And so whether you're using a lawyer to prosecute or defend a protection order, you kind of got to have an idea what that means. And what that means is, and I'll reference a criminal case because that's the easiest reference point most people know, most criminal cases need to be proven beyond a reasonable doubt in front of a jury. A civil protection order only needs to be proved by preponderance of the evidence in front of a judge or commissioner. What's preponderance of the evidence? As a practicing lawyer, I like to call it 51%. If you can prove your case by 51% and the other side's 49%, technically you should win a protection order. The other interesting thing they did was that they changed the rules of evidence. Typically, in, for example, a criminal case, you can't have hearsay evidence come into a courtroom. What's hearsay evidence? So-and-so told me that so-and-so said this. Well, that's kind of unreliable. In civil protection orders, what they've done is they've taken almost all the rules of evidence and they've thrown them out, and they've allowed the commissioner or judge to weigh the evidence based on their experience of handling an enormous number of protection order matters and their sense of what the entire story is all about and all the other evidence. So what you get is a judge or commissioner hearing the totality, the entire story, and then making a decision at the end of it. And so instead of getting a kind of a pieced up, chopped up pieces of the story that will happen with the rules of evidence typically in a criminal case, you, for the most part, can speak freely in a protection order setting and tell the entire story, and the judge will either believe you or not. What that means is that behavior that doesn't qualify for a criminal charge or a criminal conviction can be stopped by a protection order. And protection orders are just a judge that orders the other person stop. They can do a lot of affirmative things in protection orders. They can send people to treatment, they can make them change schools, they can order them to turn over cars, they can limit access to children. The list goes on. The specifics of each remedy is unique to the four types of protection orders: domestic violence protection orders, anti-harassment protection orders, vulnerable adult protection orders, and sexual assault protection orders. But needless to say, the judge is given a lot of discretion to do what they need to do to make that person feel protected. So they're effective because even if the person doesn't stop the conduct, if they violate the judge's order, the police can be called and they can investigate and prosecute based on the violation of the judge's order. So you don't need to prove they harassed you, you just need to prove that they violated the judge's order not to contact you, or not to send any Facebook to you, or not to come around your house, or not to be at your school. And so they're an interesting remedy to society's problems of how do we get along and how do we stop behavior that doesn't rise to the level of a criminal charge but should stop.